Good morning, everyone. Thanks for joining us today on this beautiful, bright and sunny Wednesday. Just kidding. So today we're going to be talking about what happens when we fail to plan for the worst case scenarios. Nobody likes to think about the day that, you may not have the capacity to make decisions about your money or your healthcare. And I understand that, but, unfortunately, these things happen. Things happen in life, and we need to have and ensure that, the proper plans are in place so that your relatives, your loved ones can take care of you if needed. So I will be specifically chatting about powers of attorney, or more specifically, what happens when you don't have powers of attorney or properly executed powers of attorney. And that's kind of on one time spectrum or time frame. And Sabrina, my colleague, will be talking about what happens when you don't have a will. So kind of the after death time frame. So I would also start today with the standard caveat that our conversation today is a general discussion. It is not legal advice. But if any of you have any questions pertaining to your specific situations, either myself or Sabrina would be happy to chat with you. Please do not hesitate to contact either of us. So I'm going to start with the general explanation of what powers of attorney are. So these are documents that allow someone to make decisions for you on your behalf if you are unable to do so for yourself. So they essentially become a substitute decision maker for you during your lifetime. Now, there are two types of powers of attorney, or POAs for short. So we've got powers of attorney for property, which cover decisions relating to money, tangible assets like real estate, intangible assets like investments, or representing you in legal proceedings, or even calling government agencies on your behalf, for example. So for the purposes of today, I'm going to be talking about typically what we refer to as a continuing power of attorney for property, which takes effect immediately, essentially from the day you sign, and continue, unless specified otherwise, and continues through any subsequent or later incapacity. So really, there's no, the document can be used without additional steps necessarily having to be taken. So the individuals, as I mentioned, appointed under a power of attorney for property can do anything with respect to your property as if it were you, with the exception of making a will. So again, becoming a substitute decision maker for your property decisions. The second type of power of attorney that we have is called a power of attorney for personal care. So this is this document covers decisions relating to your health, housing, diet, hygiene, anything personal that you would otherwise make for yourself. This type of document differs from the power of attorney for property in that it can only really take effect. Those decisions can only be made by the person that you've appointed or people you've appointed if you are actually incapable of doing that for yourself. So it's going to involve some form of extrinsic support that would, that leads the person authorized to make those decisions for you. They have to have that reasonable belief, and there has to be that support that you cannot make those decisions for yourself. So both of these types of documents do require the grantor or the maker of the document to have capacity to sign the documents. So, the way that we test for capacity, if we're, as the lawyer preparing the document, for each one, they have their own criteria, but at the end of the day, the lawyer preparing the document has to be satisfied that that individual has the required capacity or has the ability to understand the nature of the document and the consequences coming from signing such a document. Both of these documents also require that certain formalities be observed, for example, in the way that they're signed. So these, and generally, these documents, along with what I'm going to be talking about later, the applications that arise if we don't have them in place, they're governed by what's called the Substitute Decisions Act, or SDA for short. So I'm going to be talking about a couple of scenarios, which unfortunately are not uncommon. So my first case study or scenario is the case of Mrs. M. She is elderly. She's never executed a will or powers of attorney. Her husband died many years ago. At no point did the conversation about estate planning or powers of attorney come up. It just was not something that was discussed. So Mrs. M, a couple of years ago, started experiencing early stages of dementia or cognitive decline. At that point, again, no conversation came up about potentially getting powers of attorney in place. So unfortunately, we're here a few years later. Her condition has significantly declined. She is now experiencing rapid cognitive decline or dementia, advanced dementia. Most days now, she cannot recognize her relatives, friends. She cannot speak coherently. She rumbles a lot around the house. And her kids are very concerned that she's no longer able to live independently. So they're concerned for her safety. And they believe that she needs round-the-clock care, and they believe that she would benefit from living in a home that specializes in treating patients like her. So unfortunately, that home is not the cheapest. And in order for Mrs. M to be able to afford to live in this home, she will have to, her home that she currently lives in needs to be sold. Unfortunately, she's the sole owner of this property, and her children really, as there's no power of attorney, they don't really have the authority to just sell her house. So what are they to do? They consult an estate planning lawyer. They take their mother and see if, they can get a power of attorney in place. They themselves are not sure what's involved with making a power of attorney. They just know that somebody has told them, you should have this document. So they take her to the estate planning lawyer, who unfortunately says she doesn't have the required capacity to sign powers of attorney. So their only other option really is that they need to go to court, and they have to make what is called a guardianship application, which is done under as I mentioned, the Substitute Decisions Act. And it is a court application. So now they have to engage a lawyer to help them prepare this application to court. And it's unfortunately going to involve significant time and money. So a guardianship application, really what it is, as it is essentially presenting to the court evidence that the individual that is incapable is in fact incapable, and that as a result, they require decisions to be made on their behalf by the applicants, because the applicants are saying, we are the best people to make the decision for this person. So before an order is granted, a court order allowing, so in this case, Mrs. M's kids, granting them guardianship, the court has to be satisfied that there is in fact a finding of incapacity. And what that requires is going to be an assessment of some kind. So a formal assessment by an individual authorized, by a professional authorized to make these types of assessments for incapacity. So in addition to a capacity assessment, a plan for the care and management of both the property and the care decisions of Mrs. M is going to be required. So these are detailed. They have to be, really the management plan for the property. The children have to report what are Mrs. M's assets, what are her sources of income, what are there any legal proceedings currently in place, what are the plans to with respect to her property. So in this particular case, they have to report to the court that given her situation and her health, her home has to be sold, and the funds from that are going to be used to cover the payments for the care home. And in the care plan, they'll have to, report, yes, she will be moving into this care home, which has activities for patients such as Mrs. M. She still enjoys, there are certain things that still make her smile. And so, you have to report the social activities that, the applicants, or in this case, our kids, are going to try to continue to expose Mrs. M to ensure that she still has somewhat of a quality of life. So at the end of the day, the court has to be satisfied that these plans are going to meet and are in the best interest of Mrs. M. So in addition to those plans, there's going to be likely affidavit evidence, other extrinsic evidence, so other relatives who can, swear affidavits in support of their application to say that, yes, these two individuals are the best people to make decisions for Mrs. M. So that's generally, in a nutshell, what the goal of the guardianship application and what is required. Now, there's on the more technical aspect, and this is more so, for the lawyer to decide and work with the client on, because we, as lawyers, we cannot recommend that Mrs. M's children, let's say, undertake an application like this on their own. Navigating the legal system is very complex. And so we would recommend that they hire and retain a lawyer, which they did. So there's two routes really in a guardianship application that you could take two ways of presenting it to the court. So one way is kind of your standard, you gather all your evidence, prepare all the documents, submit to court. The lawyer will then attend before a judge, make oral submissions, and hopefully, if all looks good and the judge is satisfied that the conditions are met, then they will grant an order to the children saying, yes, you are now the court-appointed guardians for Mrs. M. The other option is what we call the summary route. So this is more if, it doesn't necessarily require a hearing, so it can be done in writing. So all the evidence would just be presented to the court in the form of a written package. And but it just requires additional. So in addition to all of the other documents and evidence I mentioned earlier, it also requires an additional, so two statements very specifically. So one from a designated capacity assessor with very specific statements that have to be included by that assessor. In addition to their formal assessment. And the second statement has to be done by either another assessor or somebody who has known the individual for a period of 12 months before the application was submitted. So it involves a little bit more, but it is an option. So that's something for the lawyer and Mrs. M's kids to discuss how best to proceed. So just kind of going back in terms of the procedural aspect, all of those documents do have to be served on the relatives, Mrs. M's relatives, so other relatives other than her children, even though in this situation, it makes the most sense for the kids to be appointed, but there are situations where other relatives may be a better option. And so the requirement to serve other relatives is there. In addition to other relatives, they have to serve the public guardian and trustee, which is a division of the government that essentially protects the interests of individuals who are incapable in the province. So they may need to become involved to represent the interests of the incapable. In this situation, the kids have served the public guardian and trustee. The public guardian and trustee has no issues with anything. They've served everyone that they needed to. Other relatives are in full support of Mrs. M's kids becoming the appointed guardians, and they are successful ultimately in their application to be appointed as the guardian for Mrs. M's property and of the person, her personal care decisions. So then I move to another scenario. I can give you another scenario where we have Mr. X, who is a younger gentleman, but he's very adventurous. He is quote unquote a thrill seeker. So, he realizes that he likes to engage in, fun but dangerous activities like, skydiving or, free jumping or dangerous activities. So he recognizes this and decides, I probably should have a will and powers of attorney. So he goes on Google and downloads or prints off something that he thinks will be just fine. Unfortunately, the documents are not executed properly. They're not the proper formalities under the requirements of the Substitute Decisions Act are not observed. But at the time, he has no idea because he doesn't seek legal advice. So fast forward 5 years later, Mr. X is unfortunately involved in a really bad sporting accident and has now suffered significant brain injury. And he no longer can live independently. And he must live in a special, like a group care home, basically. And his sister, who he appointed under those documents, is now faced with, she's encountering issues dealing with his banks, dealing with the care home, who has said, we need to see these documents. We cannot act and rely on these documents. We need to see properly executed documents in order to be able to speak to you further, continue to speak to you. The bank has now pretty well frozen her out of his accounts. So, he has bills that need to be paid and she's not able to help him. What is his sister to do? So in this particular case, his sister has two options. She can go to the court. Of course, she's going to consult a lawyer. Her option is she can go to the court and go through the same procedure of getting, pretty well bringing a guardianship application, or she can bring what is called an application for directions under the Substitute Decisions Act to see if, she can get an order, not necessarily rectifying the deficient powers of attorney, but to see if perhaps she can get a declaration that they are valid documents. Either way, she's going to have to incur significant legal costs. There's time in both situations. In fact, there's time, money, stress, is all of these things that could have been avoided if, the conversation had been had when they were able to with the proper professional, with a lawyer. So as you can see, this is a complex situation to navigate. I haven't even talked about how instances where family members get along. These are in the best case and the worst case scenario. These are ideal because you've got family members that get along. When they don't get along, that's a whole other conversation for another day. So again, just bearing in mind, really, the cost of these applications, assessments, these formal capacity assessments can be quite costly, into the couple of, even the few thousands, depending on which professional is engaged to do the assessment. Legal fees. There's significant time and that goes into preparing the documents. And so, that does reflect in the legal fees. There may also be the issue with privacy. When you make these types of applications, you're filing documents with the court, which can become public record. You're also having to serve the public guardian and trustee, which is a division of the government. So now you've got the government and the court pretty well, they're aware of your family business. So this may not, be a big deal to certain people, but it may for others, right? And otherwise it's unnecessary, or it could have been unnecessary. at a certain point in these people's lives. So in closing, I just want to drive home the point. It's really important to, as much as we don't like to think about the worst case scenario, it's really important to plan for it and speak to a lawyer, get your documents prepared. You invest the money up front to have them properly, executed, advised, and you are fully aware of your rights and obligations and the obligations of the individual authorized. So basically just, you don't want to end up in a situation where your loved ones are having to navigate a complex situation and a complex court system. And so the fees upfront pale in comparison to what ends up getting spent if you don't have those documents in place. So with that kind of closes off my portion of the segment. So I'm going to pass it over to Sabrina, who will talk about the next kind of time frame.
Hi, good morning, everyone. My name is Sabrina Gismondi, and I'm a will and estate lawyer at Kaiser Mason Ball. So I'm going to talk about for the next 20 minutes or so what happens when someone dies without a will. And to do this, I'm going to talk about a few myths that I hear time and time again from family, from friends, in client meetings. There's all these sort of myths that I hope that I can clarify in the next 20 minutes. And then we're going to end with, sad story of someone that died without a will and things just went from bad to worse. So let's go with myth number one. I don't need a will because I have power of attorney documents, or I don't need a will because I have a living will. Or, someone said this to me last week. My mom is my aunt's executor and my aunt is in long-term care. And so my mom as executor is making her healthcare decisions. Or I also receive these calls all the time. My mom passed away and, you should know I'm her attorney for property and personal care. So all of these statements that I just said, they're all mixed up. They're not accurate. Because there's a lot of confusion about power of attorney documents, which Daniela just spoke about, and a will, a last will and testament. So to be clear, we're talking about 3 different documents: power of attorney for property, power of attorney for personal care, and last will and testament. There's no overlap between them, okay? So power of attorney documents work when somebody is alive, but needs help with their decision-making. A will becomes effective when somebody passes away. So there's no overlap between the documents, okay? So this can often be confusing to some people. So just keep it in mind that it's really 3 different documents and there's no overlap between the power of attorney documents. They work when someone's alive. The will is effective after somebody passes away. We have clients, and I know people, they change their will 10 times over during their lifetime. People can make a number of wills during their life. You can change your will anytime you have capacity. When you pass away or when you lose capacity, that becomes the final will. Okay, so let's take a couple of minutes to talk about terms. First term is attorney. So attorney is, again, what Daniela was talking about under power of attorney documents. It's not your lawyer. And a lot of people get very mixed up with this. I think in the US, they use the word attorney to describe lawyer. But in Canada, we don't really use that term. An attorney is the decision maker under the power of attorney documents, okay? So it's not me, it's the person under the power of attorney documents. As opposed to the executor or the estate trustee or the trustee. This is the person that's appointed in a will, or we're going to talk about what happens if you don't have a will, responsible for administering the estate, okay? So the executor or estate trustee is a very different person than the attorney, and your attorney is not your lawyer, okay? But just the last thing before we leave this kind of subject on terms is this term living will. So a lot of people say to me too, Sabrina, I have a living will. Isn't that good enough? So living will is not actually a recognized term in Ontario, but some people use it to describe written decisions that they make about their preferences with regard to their healthcare. So I prefer radiation to chemo, or I prefer drug A to drug B, or I prefer to live here rather than there. Okay. And this is called an advanced healthcare directive. That's the term in Ontario, advanced healthcare directive. But for some reason, I don't even know why, it's called living will. So that is very different than your last will and testament. Okay. And not to confuse matters further, but the power of attorney for personal care and living will are even different things. Okay. The advanced healthcare directive, those are like a set of guidelines that can go along the power of attorney for personal care, but it's not the power of attorney for personal care itself. So let's leave all of this discussion about power of attorneys, because that's when somebody is alive. And we're now going to focus in on what happens if I don't have a will. Okay. So what happens if I die not having that document? And I'm going to start with, this is, let's call it myth number 2. I hear it all the time, probably once every couple of weeks. Sabrina, I know I should make a will, or else the government's going to get everything. This phrase of the government's going to get everything if I die without a will. So this is not necessarily true. What happens if you die without a will is there's a government distribution scheme that applies. This scheme is set out in a law. The law is called the Succession Law Reform Act. Okay. So the government makes a plan for you. It's like a government will. They made a plan for you just in case you didn't make your own plan while you were alive. Okay. So what does the government plan say? It says, if you have a spouse, your estate will go to your spouse and no kids. If you have a spouse and children, your estate will be divided between spouse and children. If you have a child, but that child's died and left a child of their own, like a grandchild, that person gets to participate. And by the way, that concept of children, grandchildren, the law uses the term issue. Issue is your lineal descendants, okay? So the law provides for that. If you don't have spouse and you don't have issue when you die, your estate will go to your parents or the survivor of them. If you don't have parents, it will go to your brothers and sisters. If you don't have any brothers and sisters, it will go to your niece and nephews. If you don't have any niece and nephews, it will go to your next of kin. And if you do not have any next of kin, so none of these people, the estate will go to the government. So as you can see here, the phrase go to the government, I mean, it can happen, but I don't know many people that really have no living relatives that can be found. Okay. So this scheme that I just described, that's what happens if you don't have a will. The government has made a plan for you, and the plan doesn't care if you're estranged from your siblings or if your child had special needs, or that doesn't matter. This plan is imposed. Okay. It doesn't matter on your particular situation. It's imposed on you if you didn't make a plan or a will of your own. Okay. So just to conclude that myth, it's not likely that the government is going to get your estate, but they're certainly going to have a plan for you about how your estate is going to be distributed. So maybe you heard that and you thought, okay, that's fine. And people say this to me all the time as well. Sabrina, I don't need a will because everything's going to go to my spouse. I have a spouse and everything will go to him or her. Okay, Sabrina. So I don't really, I don't feel the need to make a will. So a couple caveats with this. The law only applies to legally married spouses. It does not cover common law spouses. This means that common law spouses are totally excluded from the government plan. Okay. So if you'd like to benefit your common law spouse, you certainly need to do so in a will, or else they'll be excluded. Let's talk for a second if you have a legally married spouse, because some people say, Sabrina, that's fine. I'm actually legally married and I'm married and have 2 kids. So what happens in that situation? The spouse gets what's called a preferential share. That share right now is set at $350,000. And anything above the preferential share is split between the spouse and the children, okay? If there's a spouse and 1 child, it's 50-50, anything north of $350,000. If there's a spouse and 2 or more children, 1/3 to the spouse, and then the rest divided among the children, okay? So maybe I haven't convinced you yet, and you say, Sabrina, that all sounds totally fine. I have a spouse and children, and I'm totally fine with the government plan so far. So let me draw to your attention a couple of complicating factors. So I think complicating factor number 1 is that you really have to understand, in order to be okay with not having a will and this government plan, I think you really have to have a handle on how assets pass when somebody passes away. So bear with me here, because I want you to visualize, or if I was better, I would, try and sketch this on Zoom, but visualize 3 different buckets, okay? As estate lawyers, when somebody passes away, we gather asset information. So this person owned a house and a car and a bank account and some personal effects, and we put them into 3 different categories. Number 1 is assets that are held jointly with a spouse, as joint tenants, as we say, joint tenants, okay? So this can be your family home held jointly, bank accounts held jointly. When one person dies and they own those assets jointly, the asset passes to the survivor by what's called right of survivorship. I know a lot of terms here, but this is the law. It's called right of survivorship, okay? It has nothing to do with the will, or if you don't have a will, it has nothing to do with the government plan. The joint asset passed to the survivor because it's the law, right of survivorship, okay? Bucket number 2 are a specific type of assets, plans, and policies, which you have the opportunity to designate a beneficiary. So what's in this bucket? RRSPs, RIFs, LIRAs, life insurance, TFSA, segregated funds. This is kind of a laundry list of assets where you have the opportunity to designate a beneficiary, even group life insurance policies. So picture when, it's your first day with your new employer and there's group life insurance policy and they say, here, sign this beneficiary designation form. Or you open a new TFSA at the bank and they say, oh, here's the beneficiary designation form. Okay, so if you designate a beneficiary on that form, and that person or the persons you name survive you, the proceeds of that asset will pass to that person because they were the designated beneficiary. So again, it passes, as we say, outside the estate. Has nothing to do with the will or with this government distribution scheme if you don't have a will. It's only assets that are solely in a person's name when they pass away, or bucket number 2, but they didn't designate a beneficiary, or they designated the estate as beneficiary. That forms the estate, and that's what's governed by the terms of the will. And if there is no will, what's governed by the terms of this government plan, this government distribution scheme. So I'd really, in order to say, yeah, I'm okay with not having a will, I think you really have to understand how assets pass and that not everything necessarily comes into the estate, right? So we have to think about in our minds what's in the estate and what's not in the estate, okay? Just a little side comment here on beneficiary designation. So lots of people sign those beneficiary designation forms and then they leave it, and 10 years later, 20 years later, your circumstances have changed, you pass away unexpectedly, and there certainly could be some undesirable consequences. So let's take an example. You were married, you signed all those beneficiary designation forms, TFSA, RSP, life insurance at work, separate term life insurance policy, named your spouse, you got separated, you got divorced, you forgot to update the beneficiary designation. This is a big problem. I think people can be quite shocked to learn their ex-spouse is still named on some beneficiary designation form, right? Another thing is change in circumstances. So maybe you opened your TFSA 10 years ago when you were single and you name your brother as the beneficiary of your TFSA. You since got married and had children. And so ideally, if you pass away, you'd like your TFSA to now pass to your spouse or your children, but you've still got your brother named. So if you were to pass away, the bank will pay out to your brother because he's the person that's named, right? So really important to review what assets you own and how you own them. Are they joint? Are they sole name? Do they have beneficiaries designated, etc.? Okay, so a good estate planning lawyer and a good plan will look at all of these factors. So not just looking about the will, not just looking at a will, but looking at the entire plan. And a lot of people say to me, why is it called an estate plan? Why don't you just say you're making somebody's will? Because it's about the entire plan. The will, as you can see, is just one aspect of the whole plan. Okay. So maybe you say, Sabrina, okay, this is all good information. I'm still not convinced. I have a really good handle on how I own things. You know, I'm confident everything is joint and I've got my beneficiary designation set up properly. Complicating factor number 2 is when minors are involved or incapable people are involved. And by involved, I mean they inherit, okay? So when a minor person inherits, if you have no will, so let's say you pass away and you have a spouse and 2 children, and the children are 5 and 10. So those children are minors. Anybody under 18 is a minor in Ontario. The interests of minors are represented by a government office called the Office of the Children's Lawyer. Represents the interests of minors across the province, okay? And this is not necessarily a bad thing. It's a good thing that we have, you know, a government body who's overseeing the legal rights of minors. But it's a complicating factor because now all of a sudden, I think as a spouse or whoever it is that's trying to administer the estate, you're dealing and you're negotiating and you're accounting to the Office of the Children's Lawyer, who's overseeing the administration of the estate on behalf of those minors who have an entitlement. Another factor that people often find shocking is that parents are not the guardians automatically of their minor children's money, okay? So the law is such that parents can hold in trust for their children up to $35,000 currently of the child's money for their benefit. Anything above $35,000, parents are not permitted to hold on behalf of it if it's the child's money that, you know, that 5-year-old has just inherited $500,000. A parent is not automatically entitled to manage that money for the child. So what happens to it? It gets, the phrase is paid into court. So when a minor inherits under this government distribution scheme and it's above $35,000, the money gets held by what's called the accountant of the Superior Court of Justice of Ontario. They hold it in a pot of money with all the other money that they're holding. I think it's like hundreds of millions of dollars or something that they hold and invest on behalf of people. And it gets paid to the minor once they turn 18 years old. And it doesn't matter what type of life circumstance that minor is in when they're 18, whether they're in with a good crowd or a bad crowd, it gets paid out because they've attained that age of majority, and it gets paid out to them. Okay, so I think this is quite shocking. And this is one of the, I can't stress it enough, when you do proper will planning with an estate planning lawyer, the lawyer should be talking a lot about trusts for minors. And our trust for minors, we do not recommend payout of the trust at 18 in the will. So I'm talking about a trust that's created in a will that you can make, right? We recommend the age 25 or 30 or some sort of stage distribution where maybe it's a much more appropriate age for a young person to be inheriting a significant amount of money, okay, from mom or dad's estate. So complicating, now I'm still on complicating factor number 2. I had mentioned incapable people. So what happens if an incapable person inherits? Well, Daniela had mentioned in her part of the presentation that the interests of incapable people are represented by another government body, which is called the public guardian and trustee. So the public guardian trustee becomes involved to oversee and negotiate and ask questions and account on the administration and ask for an accounting of the administration of the estate, okay? Another very tricky thing about incapable people that inherit is maybe this person has special needs and they're on a government program called ODSP. And they're receiving income support from an ODSP program, or they receive some other benefits as a result of that program. If they inherit a significant amount of money from somebody's estate, mom or dad's estate, or whatever it is, even a sibling, depending on that government distribution scheme again, it could disqualify them from their ODSP, which is I've seen it happen. And it's quite a big deal for, you know, that person that all of a sudden they were getting government benefits. Now they've received an inheritance, which is great. But that inheritance is maybe not enough to cover them for their lifetime. And they really would have preferred to stay on ODSP, but there was no planning done. So that's another thing, that having a proper will and a proper estate plan, an estate planning lawyer would canvass those issues. If there's special needs beneficiaries, especially that are on ODSP, there's a very special type of trust we can set up in the will for that person, so as not to disqualify them from their ODSP benefits. So you lose all that if you fail to plan. So you can see that, there are unintended or undesirable consequences that just kind of keep going if you just go with a government distribution scheme and say, hey, I really don't need a will. Okay. But if I still haven't convinced you, maybe you say, Sabrina, this is all fine. None of this applies to me. I have a legally married spouse. I have 2 adult children. They're fully capable. I really still don't see the benefit to making a will. My family will figure it out. My family is so close. Nothing, there's no friction in the dynamic. They're close. They'll figure it out. I want to be very clear that if there's no will, there's no estate trustee automatically appointed, because it's the will that appoints an estate trustee. Okay. So not even the closest family member, not even your spouse, can administer your estate without applying to court to become the estate trustee. So how does this play out? Someone passes away with an investment account for $300,000 that's solely in their name, and spouse goes to try and collect it and say, my husband's just passed. I know there's an investment account here. Here's the death certificate. Here's my ID. Can you please pay out that money to me? I'm the spouse. And the bank is going to say, sorry, you're the spouse, but you're not the executor. We need proof that you're the executor of this estate before we pay out these funds to you. Okay, so that's how this starts unraveling. And the spouse or whoever it is has to make an application to court. And I recommend that a lawyer be involved in this process, because it's a pile of forms and it gets quite complicated in order to become the legally appointed executor. Okay, not to mention, family dynamics might change. And I've seen this happen in the sense that even the closest of families, like when mom and dad's not there anymore, and a referee or step in, friction happens and family dynamics change. And I think the best thing you can do is make a plan so that you don't leave a mess, right? You don't want to leave confusion or more opportunity for conflict during that time. Okay. So maybe you say, all right, so who can apply? Who can apply to do this executor role if there's no will and now somebody's got to step in and apply? Well, the law has this whole laundry list of who can apply and their qualifications and that sort of thing. So here's kind of a glimpse at the list. The person must be in Ontario. You cannot not be a resident of Ontario and apply to be an executor if there's no will. Okay, so if you die and both of your sons live out in Calgary, it's a problem because they don't have entitlement to apply. They can't be under 18 years old. So, if you've got the most mature 16 and 17-year-old out there, they can't apply. You have to be over 18 years old. Your spouse can apply. What's really interesting here is your common law spouse can apply, which maybe you think about that dynamic. But so common law spouse doesn't have an entitlement if you don't have any will, but they can apply to be an executor. And then it kind of goes down the list. So if a spouse is not going to apply, adult children can apply, or adult grandchildren or other lineal descendants, and that sort of thing. But then it just gets even more complicated, because with this application, there's forms called a renunciation. So everybody that had a priority or equal priority for you to apply to executor has to sign renunciation saying, I won't do the job. I agree that this person should do the job. Consents also have to be signed. So the majority of the beneficiaries of the estate have to get together and sign consents when the proposed executor is applying to court. This is all fine. I mean, it's extra paperwork, but it's very problematic if minors inherit or if incapable people inherit. Why? Because those people cannot sign renunciations and they can't sign consents. And so that's where, the Office of the Children's Lawyer or the Public Guardian and Trustee, they really step in to represent that minor or that incapable person. So as you can see, it's just getting more and more complicated because there was no will. The next point is that there has to be a bond. And you might think, Sabrina, what's a bond? A bond is an insurance. So the proposed executor has to go out and get insurance. And the reason why the court requests this is because the court doesn't know you. The court doesn't know what your circumstance is, or quite frankly, if you're going to skip the country, if you get access to estate, right? Get access to the estate. When you have a will and you appoint an executor, the court doesn't have this requirement because the court trusts that you appointed the right person and you appointed a trustworthy person. But when there's no will, how is the judge supposed to know? Okay. In some cases, the lawyer can help the proposed executor to waive the bonding requirement. It might work in some cases, but again, the bonding requirement cannot be waived if there's minors, if there's incapable people, if there's creditors, generally if the person was running a business. Because again, the court wants to make sure that they're really appointing the right and a trustworthy person, and then that person is not going to leave the country with the estate money. So this is a whole other complicating factor of going out and trying to get this bond, this insurance, or asking the judge to waive a bond, and your application package is suddenly going up to a judge, and it's not just being administered by the court clerks at any one courthouse. So as you can see, it just gets more and more complicated. And all of this could have been avoided, quite frankly, if you died with a valid will. Okay. So although I don't like to do this, I'm just going to spend 5 minutes on a sad story about what happened when someone passed away unexpectedly without a will. So this is a story about a young family, a totally average young family. So a couple in their 30s with 2 young kids. The kids were 3 years old and 1 year old, and the husband unexpectedly died. Okay. The couple had, let's call them average assets. They had a house, they had investments, RSP, TFSA. So what happened was the surviving spouse, the wife, went to go collect the investments. And her husband did a little bit of trading with Quest Trade. Okay. So let's call it that there was $200,000 in a bank account with Quest Trade that was solely in his name. So it wasn't joint. So she tried to collect that money, and you need money. She wasn't working anymore because this horrible tragedy had happened, right? And you tight on cash, and there's the funeral and the mortgage and all this stuff. And the bank, Quest Trade, says, sorry, but you're not the executor. We need proof that you're the executor before we release these funds to you. So she hits a roadblock. Okay. So now she goes to call the financial institution where his RSP and TFSA are held. The beneficiary designation, he named her for 50% and the 3-year-old for 50%. So she had no problem collecting her money. She filled out the paperwork, showed ID and the death certificate. She was able to collect 50% of the proceeds. But for the other 50% of the proceeds, it was over $35,000. And so the bank said, sorry, even though you're this person's mother, you don't automatically have responsibility for, your son's money. What we're going to have to do is we're going to have to pay these proceeds into court, and your son can go to the court to collect the proceeds when he's 18 years old. Again, very undesirable outcome. She thought this is the most trusting of situations. She thought she could just, hold that money and put it in a bank account until, he needed it for school or whatever, but it's not possible. It's being paid into court now. Okay. And then things just went from bad to worse, because she goes to a lawyer to try and, transfer the home to herself. Surely she's the spouse, so she's going to inherit the home. So it turns out that the husband had purchased the home before they got married, and the home was only in his name. So it wasn't held jointly as joint tenants. What does this mean? Well, reflect back on the conversation we just had about those different categories of assets. It fell into category number 3, which is the solely held category, which forms part of the estate, which is governed by this government plan. So the house did not pass jointly. It was not joint. It's now part of the estate. So the first $350,000 of value, she has an entitlement to that. And then she has some entitlement 1/3 but the rest of it is divided between the two kids. The two kids are 3 and 1. And so the Office of the Children's Lawyer has to get involved. This took years to work out, and they had to go in front of a judge to explain this whole situation because, of course, she wanted to continue to live in the house, but she had to, quote unquote, buy out the house from the children, buy out the house from the estate, right? And a judge needed to approve this. This took several lawyers. It took thousands and thousands of dollars in legal fees. And I think what was the saddest part is you can start to resent your spouse, right? Because why didn't we just make a will? Why didn't we just meet with the lawyer? We had 2 young kids. We got married. Circumstances have changed. Why didn't we just spend the money and the time to make a plan? So I'm sorry to tell such a sad story, but I really, really hope that this emphasizes that I think that making a plan is the best thing you can do for your loved ones, for better certainty, right? That things will be organized and there's not going to be confusion and chaos if you pass away. So I just want to conclude by giving you an idea of if you were to complete, if you go to an estate planning specialist, what does this look like? Like, what does making a will and a power of attorney look like? So this is kind of a sketch of how the project might look if you work with an estate planning lawyer. At least this is the process at our office at Kaiser Mason Ball. Okay. So the first thing we do is we need to collect personal and financial information from you, and we do so using a questionnaire. A lot of estate planning lawyers send out this questionnaire because, of course, in order for us to give you tailored advice, we have to know about you. So the lawyer will review the questionnaire and they're going to ask, how do you own a house? How do you own it? Are you sure you own it jointly? Or are you sure, do you have TFSAs? Do you have life insurance, et cetera, et cetera, et cetera? How old are your kids? Is there any special needs beneficiaries? There's kind of all these questions that we ask in this detailed questionnaire. Then we meet. Okay. So the meeting is usually 1 to 2 hours, could even be more, could even require multiple meetings until such time as we can take your drafting instructions. So you're ready to give the lawyer instructions about your will and power of attorney. The lawyer drafts the documents, sends them to you for review. We have a review call. And then you attend at our office. So after you're fine with the documents, you come into the office to sign in accordance with the formalities that Daniela discussed, which is in the presence of 2 witnesses who are both there at the same time to make sure that everything is signed properly so that the plan is actually effective. Okay. And we call it the plan or the project because it's, again, not only the will, but it's the entire estate plan. And it's not only the will, but it's the power of attorney for property and power of attorney for personal care documents. And there's tremendous opportunities for planning once you get into these detailed discussions. So I mentioned some of them earlier, but great opportunities to put trusts in the will for minor children. And we have kind of a very robust conversation about the age that those children should inherit. And, it depends on the nature of the child and the amount of wealth involved. Should it be 25? Should it be 30? Should it be a lifetime trust or some age in between? Or should we have a staggered distribution? Trust for special needs beneficiaries. In particular, as I mentioned, if one of your family members is on ODSP and you wish to benefit them, setting up a very special type of trust for that situation in the will. And then I know there's a lot of business owners on this call, and there's just such good planning opportunity for business owners, especially those that hold shares in a private corporation, privately held shares. You can't believe it, but there's planning strategies where people have not 1 will, but 2 wills to try and save probate tax. So there's all sorts of kind of really interesting strategies to try and have very efficient distribution of your estate. And the lawyer will canvass all sorts of things. Do you have foreign assets, businesses, that sort of thing, to make the plan as robust and as tailored as possible. So I'd like to thank you so much for your time today. Thank you for your attention. And if you have any questions, please call.
Thank you so much to you both for presenting today. Again, if anyone has any questions, you can drop them into the chat. We have a few minutes. We do have one question here, and I'll combine them. The question is, what is the age requirement of a person who can be a POA or a guarantor for a will?
So the age requirements are a little bit different for the property versus personal care. So for property, the age requirement is 18. So the individual appointed has to be at least 18 years of age or older. For personal care, the age of that individual should be 16 years of age or older, though, 16 is quite young. So typically, if we're having a conversation, even 18 nowadays, it can be quite young. Oftentimes, we'll suggest someone who's a little bit older.
Perfect. Thank you. Thank you for the presentation. Very informative. So is there anyone else that wants to ask a question?
I can just mention a comment that came up in the chat. Someone said, you need to mention Henson Trust Fund for ODSP clients. So Henson Trust is the word for the type of trust that we can put in a will for a beneficiary that is on ODSP, so that when they inherit, they don't lose their ODSP eligibility. A lot of people come in saying, I'd like a Henson Trust because, my son or daughter has special needs and I've heard about this. And then they're very surprised to know that when I send them the draft documents, there's not a Henson Trust word Henson mentioned anywhere in the document. So Henson Trust is a name of a case that went to the Supreme Court of Canada, where it was decided that this trust was allowed. This concept of a trust, and the person can still stay on ODSP. So that's definitely something that our office does a lot of, and is a very important type of planning for special needs beneficiaries that are on ODSP. So thank you for that comment there. And so important to do that type of planning, not just leave it to chance and not have a will, especially for special needs beneficiaries.
Definitely. Thank you so much. So that concludes our event for today. I want to thank you both for presenting and providing so much information. I hope all of you enjoyed today's webinar and the information that was provided. Again, we did record this event, so it will be available on our site in the coming days. And we want to thank Kaiser Mason Ball for hosting today's webinar. Have a great day, everyone. We will see all of you soon. Take care.